Hello, I'm Constitutional Attorney Katherine Henry, and today we're going to go over 102 of the most common legal terms used in civil cases. Now, this is a companion series that goes along with our videos on general legal terms, as well as a series on common legal terms in criminal cases and common legal terms in appeals. So again, this one, though, is specifically about the common legal terms in civil cases. And there are a few words that will be brought up or defined in 2 or 3 of the videos, but this one has the most common terms that you need to know in any civil case. So, action, that is a lawsuit or a legal demand for one's right to be asserted in court. Action in rem, a lawsuit to determine title to property. Allegation, the position of a party to a lawsuit, as stated in the pleading. Amicus curiae is essentially a friend of the court, although not the same friend of the court that Michigan uses in custody and divorce cases, but a different kind of a friend of the court, where it's someone who's not involved as a party, who intervenes in a lawsuit to volunteer information on a point of law to assist the court in deciding the matter before it. Ancillary. An ancillary suit, for example, is a lawsuit growing out of and supplementary to another lawsuit. So, for example, a suit seeking enforcement of a judgment would be separate than the original lawsuit that obtained the judgment. An answer. The pleading in which the defendant states his or her position concerning the plaintiff's allegations and sets forth the grounds of his or her defense. So it's typically their first pleading, although a motion to dismiss might be the first pleading, or the motion to dismiss might be filed with the answer, but answer is typically one of the first couple of pleadings filed by the defendant in a case. Appearance. It's coming into court. It's the formal act by which a defendant submits to the jurisdiction of the court. Attachment. That's the act of seizing a person or property so that the person or property comes before the court and is subject to its judgment. A brief. It is a written argument submitted to the court by counsel or the person if they don't have an attorney, setting forth the facts and the law supporting the client's case. Burden of proof. We just did a series. We have a small video, I should say, that just came out on the standards of proof, the burden of proof in civil and criminal cases. So check that out. But in general, a burden of proof is the duty to establish a fact or facts in dispute. So, for example, the plaintiff in a personal injury lawsuit has the burden of proving that an injury occurred and that the defendant caused it. Caption. The heading of a document prepared for consideration as part of a court proceeding, showing the names of the parties, name of the court, number of the case, like the docket number, the court file number, etc. Challenge for cause. That's an objection to the qualifications of a juror for which the reason is given, usually on grounds of personal acquaintance with one of the parties, so a conflict of interest, for example, or the existence of a bias that may affect the verdict, where there would not be otherwise an impartial jury. Challenge to the array. That is to question the qualifications of an entire panel summoned for jury duty, usually because of alleged partiality or some deficiency in the manner by which the panel was selected and summoned. Change of venue. The removal of a suit started in one county or district to another location for trial, usually on the basis that one of the parties cannot obtain a fair trial in the original county or district. Circuit court. It's the highest trial court of original jurisdiction in many states, such as Michigan. Some jurisdictions have multiple different trial courts, perhaps a probate court, a district court, and a circuit court. And generally speaking, where you have multiple different kinds of trial level courts, that are not appellate courts. The circuit court is generally the highest of all of those trial level courts. Circumstantial evidence, indirect or inferred evidence as distinguished from direct or eyewitness evidence. For example, just before retiring for the night, a man looks outside and sees that the ground is bare. When he awakes the next morning, he sees that the ground is covered with snow. He concludes that it snowed during the night. The evidence on which he bases this conclusion is indirect, because he didn't see it snowing, or circumstantial. So, because he didn't actually see it snow, but he infers that it did from the result. Civil actions or suits. That is generally a non-criminal case concerning the claim of one private individual against another, although sometimes governmental entities do bring civil or quasi-civil cases against individuals. Claim, to demand or assert. Comparative negligence, the doctrine by which acts of opposing parties leading to an event are compared in their degree of negligence, and recovery is permitted according to the degree of fault for each party, often on a percentage basis, as distinguished from contributory negligence. So, for example, you have comparative negligence. Often this arises in terms of like a car crash. If it's a comparative negligence jurisdiction and you have a trial and it's showing, well, driver A had, they were 25% responsible for what happened, but driver B was 75% responsible for what happened. Then if they look at things and go, well, if only one person had been at fault, we would have awarded $100,000 to driver A. Then with the comparative negligence standard, what they do is they say, well, you would have gotten $100,000 if the other party was completely at fault. But because you shared 25% of the blame here, we're going to reduce your award, your judgment, by that 25%. So you would then be awarded $75,000 in this example. So that is comparative negligence. Complainant, one who seeks legal redress, one who brings the case to court. So it's generally the plaintiff in a civil action or one who calls the police to report a crime. Complaint, the first pleading by the plaintiff in a civil action setting forth his or her claims. Now, in some jurisdictions, you might technically have a summons, but usually you have a complaint first and then a summons directing the defendant to answer the complaint. Contract, an exchange of oral or written promises between two or more parties to do or not do a particular thing, enforceable by law. Contributory negligence. Now, this contrasts to the comparative negligence we talked about a moment ago, and this is a doctrine that prohibits recovery of damages by a plaintiff whose own behavior contributed even slightly to the event that caused the plaintiff's injuries. So in that situation, let's say it's a contributory negligence jurisdiction and it's that same car crash, and they have found, the fact finder found, that the plaintiff was 25% at fault and the defendant was 75% at fault. In a contributory negligence jurisdiction, the fact that the plaintiff was even the tiniest bit at fault, it could have been 5% at fault. As soon as they're found at fault at all, the defendant's obligation to be held responsible is wiped away. So, pretty intense situation. The comparative negligence standard, in my view, is a lot more appropriate and fair and just for most circumstances, but it is what it is. Make sure to check out our other 5 videos in this mini-series, as well as our mini-series on general legal terms, criminal trial terms, and appeals case terms.